Okay, now I would like to invite Rick Antonoff, who is a great practitioner, very well experimented. He has had a lot of practice from the United States perspective in other jurisdictions. He is from Blank Rome, New York, United States. Rick, please.
Thank you, Dario, and welcome everybody. I assume that if you're still here this late in the afternoon, you must really be interested in international insolvency. I want to thank my dear friend Otto Lobo, my new friend Dario Oskas for inviting me to speak with you this afternoon on this Untertral panel. I'm going to speak somewhat briefly about Untertral and then move on to describing two very recent court rulings that may result in something that Untertral, the Insolvency Working Group, may take up in the future. And I think it really does bring to light some of the issues between universalism and territorialism. Dario had mentioned that the most recent pronouncement by the Untertral Working Group 5 that was adopted by the United Nations Commission on International Trade Law was the model law on recognition and enforcement of insolvency-related judgments. We're fortunate that we don't have to go into the details of how that law works and how it came about because my colleague and I wrote a report on that, the background giving rise to the new model law, describing some of the relevant provisions of the model law and how it works and how it might actually become enacted.
You can give me one of the reports.
Okay. And I have several copies of the report up here, so you can come in and take a copy. It's in English, but it's only about 10 pages, so it's a pretty quick read. What gave rise to the model law on insolvency-related judgments is really two court decisions, one from a court in the United Kingdom that declined to recognize and enforce a judgment that arose in a bankruptcy case in the United States, and a second decision in which a court in the United States declined to recognize and enforce a judgment that arose in an insolvency case in Mexico. I don't believe that had there been the model law on recognition and enforcement of insolvency-related judgments prior to those decisions, that they would have come out differently. I think the results would have been the same, but the procedure leading to those results would have been different. And I want to give just an example of how I think the model law on insolvency-related judgments could be used in a way that I think makes a lot of sense. And I'm going to use two cases that I was involved in, both of which happen to be about Brazilian companies. And I think it may show how this new model law can be used. One case was Rede Engenharia, and the other was Odebrecht Oil and Gas. Both cases were Brazilian judicial recovery. Odebrecht was an extrajudicial recovery, but they both resulted in recovery plans, being approved by the courts in Brazil. Those plans contemplated an exchange of old debt for new debt, and this was public debt, and so there was, in both cases, an indenture trustee whose responsibility it was to conduct the exchange offer, to cancel the old debt and then distribute to the creditors the new debt. There was, in both cases, a small number of creditors, bondholders, that objected to the plan and to the treatment of the claims that they held as bondholders and objected in the Brazilian court. They were outvoted by the majority of the bondholders who approved the plan, and their objections were overruled by the Brazilian court. But the indenture trustees made as a condition, and the bondholders who were in favor of the plans had as a condition to the exchange offer built into the plan that following approval of the plans by the Brazilian court that the debtors would seek relief under Chapter 15 of the United States Bankruptcy Code, an order recognizing and enforcing the order approving the plans that was issued by the Brazilian courts. To do that, the debtors had to file a Chapter 15 petition and obtain recognition of the foreign proceeding, a recognition of the foreign representative as a foreign representative, and go through the hoops and hurdles of getting recognition under Chapter 15. Had there been a model law on recognition and enforcement of insolvency-related judgments, I think that those foreign representatives could have come to the U.S. court and just obtained recognition and enforcement of those orders. And the reason the indentured trustees wanted that as a condition in the plan is that they were concerned and were exposed to lawsuits by the objecting bondholders who could have sued the indentured trustees in the United States and saying that by conducting this exchange order, they were violating their duties as trustees. And whether those claims were meritorious or not, or would have prevailed, the indentured trustees wanted to avoid that litigation, I think sensibly so, and so obtained orders of the bankruptcy court that enforced the Brazilian bankruptcy plan and precluded holdout bondholders from bringing those lawsuits. So that's one way in which the new law could be used. What I really want to talk about, though, are these two other decisions that I think the Insolvency Working Group of UNCITRAL may consider, and I'll tell you that I have no presentation for this because I just decided yesterday that this is what I was going to talk about, and that is because it involves two recent court rulings. The most recent one was released on Monday, the day before yesterday, and I've been thinking about it, and it's gotten a lot of attention by international insolvency practitioners. I will give you the facts of the case and the two court rulings. I will tell you that the earlier of the two court rulings comes from the Court of Appeals, the United States Court of Appeals in the Second Circuit, which covers bankruptcy cases in New York. And the second ruling comes from the highest court in the British Virgin Islands, the BVI, it's called the Privy Council. Both cases arise from the collapse of the Madoff Securities firm, which I'm sure most, if not all of you, are familiar with. Madoff Securities was a company run by Bernard Madoff that was in name a stockbroker that bought and sold stock for its customers, or at least was supposed to buy and sell stock for its customers. It was discovered and revealed in 2008 that what Madoff Securities actually was a Ponzi scheme in which money from new investors was used to pay returns, falsified returns, and redemptions to older investors. When Madoff Securities collapsed, it was placed into liquidation in New York under special provisions of the United States Bankruptcy Code that deal with stockbroker liquidations. And in those cases, a trustee is appointed immediately. Prior to the collapse of Madoff Securities had taken in investments from new investors and had paid false returns based on stock purchases that were never made, and had also paid out redemptions to its investors, its immediate investors. The immediate investors of Madoff Securities were what are called feeder funds, and these are funds that were created under the laws mostly of the Cayman Islands and the British Virgin Islands. The biggest feeder fund that was the investor in Madoff Securities was a BVI fund called Fairfield Century. So Fairfield Century and the other feeder funds got this money directly from Madoff Securities and then passed those payments on to their direct investors, also located outside the United States. And so the first transfer from Madoff Securities occurs from the United States to either BVI or Cayman, and then a subsequent transfer occurs from either BVI or Cayman to another transferee outside the United States. The feeder funds, because they had invested in Madoff securities, were themselves the subject of liquidation proceedings in Cayman and BVI and had liquidation trustees appointed in those liquidation proceedings. The bankruptcy trustee for Madoff securities in the United States brought a fraudulent transfer claim against the feeder funds for the initial transfer from Madoff securities to the feeder funds to have those declared fraudulent transfers that were made for less than reasonably equivalent value in exchange. And then once that judgment was obtained, that initial transfer was avoidable as a fraudulent transfer, there is a separate section of the Bankruptcy Code, it's section 550A, that allows the trustee to recover the property that's transferred or its value, either from the initial transferee or from any subsequent transferee. Now remember that the subsequent transfers in these cases occurred entirely outside the United States. And so the question arose in the Madoff securities case is whether the liquidation trustee would be able to recover the property that was the subject of the subsequent transfer from a transferor outside the United States to a subsequent transferee outside the United States. In other words, the question was whether the fraudulent transfer recovery provisions of the U.S. Bankruptcy Code applies extraterritorially outside the United States. The question of the extraterritorial application of avoidance actions and recovery actions is one that has been very controversial in the United States, has not received a consistent reading, even within a single district in New York, as the Southern District of New York has had inconsistent rulings on that. The majority of cases do find that the recovery provisions for fraudulent transfer do not apply extraterritorially, and there's two main reasons for that. One is that there's a very strong doctrine under U.S. law that U.S. laws do not apply extraterritorially unless Congress has clearly expressed its intent that the law apply extraterritorially. And most cases have found that there was nothing in Section 550A that clearly showed that it was intended by Congress to apply extraterritorially. The second part of that test is whether the application that the trustee is seeking to use is in fact extraterritorial, or whether it is a domestic application of the law, which would be permissible, even if it involves a transfer that occurred outside the U.S. Is it a domestic application of the law? Courts also consider international comity and whether the court should defer or decline to act because there is a proceeding going on in another country that could affect the same parties. Two lower courts, the Bankruptcy Court and the District Court in the Southern District of New York, ruled against the trustee, dismissed the actions, and found that Section 550A does not apply extraterritorially, and they also found that as a matter of international comity, that these courts should decline to act and allow, particularly the liquidation of the feeder funds in BVI and Cayman, decide whether the transfers to the investors in the feeder funds is recoverable. At the end of February of this year, on further appeal, the trustee appealed the district court decision to the U.S. Circuit Court of Appeals for the Second Circuit, and the Second Circuit reversed and concluded that the trustee's application of Section 550A to recover property from the subsequent transferees outside the United States was a domestic application of the law because it is merely the remedy for the fraudulent transfer that was avoided, which clearly occurred in the United States. And that the avoidance provision, Section 548, which is the fraudulent transfer provision, and Section 550A, which is the remedy, the recovery provision, really work in tandem with each other. And so it was a domestic application, and the trustee could pursue those actions. The investors, the subsequent transferees in the case, have already publicly indicated that they intend to seek review of that decision from the United States Supreme Court, and that would be the last word on it. That is the highest court in the United States. And they have until the middle of June, I guess about 3 or 4 weeks from now, to file that petition. One of the analyses of that decision is the risk that these investors, from whom the Madoff Securities trustee may recover property, are subject to and vulnerable to double liability, because there are also liquidation proceedings going on at the feeder funds in BVI and Cayman, and those trustees in those liquidations are also seeking to recover property from those same investors. The reason why this caught my interest and thought it would be worth talking about today is that on Monday, in the Fairfield Century liquidation case in BVI, the highest court, the Privy Council in BVI, ruled that, in fact, the liquidation trustee of Fairfield Century can seek to recover from the investors. And so there is a real risk of double recovery, and I think that that is potentially a problem. I think it goes against the idea of universalism. There could be inconsistent results, and I wanted to bring those two rulings to your attention. Thank you.
Very, very, very interesting, Rick.